Please rise.
Okay. Once again, be seated, ladies and gentlemen. Okay, ladies and gentlemen, once again, I thank you for your patience. In every jury trial, the court tells the jury to evaluate the case on the law as it is given to them. The court admonishes them not to apply their own conception of what they believe the law should be. I can follow no different directive. On Thursday of last week, the jury found that the aggravating circumstances outweighed the mitigating factors beyond reasonable doubt, and therefore found the verdict of death to be appropriate. The defendant on numerous occasions indicated to the court that he would not be presenting mitigating evidence. Upon announcement of the verdict, he indicated that he did want to have an evaluation performed. The court prevailed upon the court psychiatric clinic to prepare a mitigation report. The defendant issued a subpoena to have the doctor appear in court. When it was time to call the doctor to the stand, the defendant rested, much to the surprise and the chagrin of the court. A sidebar conference was held, and the defendant, acting pro se, stood fast and rested. Thereafter, closing arguments were heard, and the jury charged. The jury verdict was returned and read. The jury was polled and discharged. The defendant then requested that the court review both the pre-sentence investigation report and the mitigation report, neither of which were submitted to the jury. The court did review these documents and has evaluated this case in conjunction with the mitigation phase and the mitigation factors of 292904B of the Ohio Revised Code, as well as the statements adduced herein today. In addition to the mitigating factors in ORC 292904B, the court has considered the statements of 6 family members, all of whom relate that the defendant had a tough childhood. His older sister indicated that at age 5, he found his mother's gun and shot himself in the leg. The mitigation report, prepared by the court psychiatric clinic, adds some more significant insight. He found his mother's body after she OD'd on heroin when he was 19. He was hit on the head with a brick at age 12 and suffers from seizures. At age 9, he was repeatedly raped by his mother's male friend. According to a 2008 psych evaluation, the defendant has chronic problems with anger and has little regard for authority. There was a suicide attempt at the Euclid jail in 2006. Dr. Radio diagnosed him as having post-traumatic stress disorder. And finally, a 2018 evaluation at the Moritz Forensic Unit at Twin Valley Behavioral Healthcare observed the defendant interacting appropriately and logically with staff and others. Notwithstanding this, these mitigatory observations, the court, after carefully weighing the statutory mitigation elements, the testimony of the defendant's witnesses, the unsworn statement of the defendant, and the pre-sentence report and psychological evaluation report, the court finds that the aggravating circumstances do outweigh the mitigating factors with proof beyond reasonable doubt. At this point in time, Mr. Mazzone.
Thank you, Your Honor. Your Honor, with regard to the sentencing on the other 8 counts, that the non-homicide counts that remain, first and foremost, Your Honor, the state of Ohio, we're only here today as a collective effort and a team effort, and the state wants to thank the Cleveland Police Department, including the Homicide Unit, the Crime Scene Unit, the Scientific Investigation Unit, and the 5th District, the FBI, the Medical Examiner's Office, and the Cuyahoga County Regional Forensic Science Laboratory. Without these entities, we can't put a thorough case on as we did in this matter, and we can't produce and establish and present evidence as overwhelming as we were able to do in this particular case. Before the state says its piece, Your Honor, I know this would be an appropriate time for family members typically to address the court. Nobody from the family wishes to address the court in open court at this time. However, Your Honor, I don't want you to think that they certainly aren't feeling the effects of this, Your Honor. You've seen them sitting in the courtroom every single day of this trial, from the time we began the general voir dire until up to and including today behind me. Your Honor, over the last 2 years, the Kuznicks, the Zakowskis, they've been with us every step of the way and have been more than patient, and we've had their full support, but they do not wish to address in open court today. However, Your Honor, as you're well aware, the murders of Michael and Trina and the subsequent closing, the necessary closing of Mr. Carr's, had a great effect on the North Collinwood neighborhood. And the businesses in the area, the families in the area, and Your Honor, at this time, on behalf of the neighborhood, on behalf of the citizens of Collinwood, Councilman Mike Polensek would like to address the court.
Thank you. Councilman?
Everything has been building to this. The prosecution has argued future danger, lack of remorse, and irreversible harm to the victims' families and the community. The defense has no final emotional appeal left. From here on out, it's pure consequence. This isn't about arguments anymore. It's about finality.
Thank you, Your Honor. I, too, would like to thank the jury, Cuyahoga County Prosecutor Michael Malley and his magnificent team of prosecutors, Detective Eccles, members of CPD, the Homicide Unit, the 5th District, and all the other law enforcement agencies that were involved in this process. Your Honor, from day one, this was never about vengeance. It's been about justice. I stood there on that Good Friday night as they carried out Mike and Trina and Axel in body bags. I was there. I saw the pictures from the coroner. I saw what this individual did to them, the viciousness of the crime. He is a demonic killer, a demonic killer. It's one thing to rob somebody, but it's another thing to do what he did. Him and his cohorts, what they are predators. They prey upon our communities, upon our businesses, upon our citizens, and as we try to stabilize and rebuild our neighborhoods and our city, this is what we have to be confronted with. The North Shore Collinwood area, the greater Collinwood community is a great neighborhood. This crime on Good Friday not only devastated the family and tore that family apart, it devastated the community because they didn't know, the businesses didn't know who was going to be next, if there's going to be somebody else. It could have been somebody else. It was Mike and Trina. It was their night to be preyed upon by him and his cohorts. What we want, Judge, and what we're asking for is justice on behalf of the people, of the community, and on behalf of Mike and Trina's family. He'll be around tomorrow. Mike and Trina aren't. They are not there. I saw what happened to that family. I saw what happened to that business. I've known this family for almost 40 years, how they contributed to our community, how they were supportive of one event, one activity after another. Since that brutal murders, that business has been closed. Other businesses have been apprehensive whether to invest in the community. But you know what? We're not going to let him and the other two parasites that were with him destroy our neighborhood. We're not going to let them destroy communities. We're going to rise above it, not only in this community, but across the entire city. That's the message we're looking for the court to send today, that when you commit these atrocities, there's a price to pay. There's a price to pay. And all the work that these fine folks did here, all the investigators, was not in vain. And to remember what this family has gone through. I know how many times I've talked to them on a phone and have heard and the pain in their voice, saw what happened, was there. We want and deserve justice on behalf of Mike and Trina and Axel, on behalf of the greater community. Thank you.
Thank you, Councilman.
Thank you, Your Honor. May it please the court again. Your Honor, with regard to the non-capital counts, the 8 remaining counts, the state is here today to first ask for consecutive sentences. Your Honor, pursuant to the Ohio Revised Code, we believe that consecutive sentences are necessary to protect the public from future crime, not only to punish the offender, and that they would not be disproportionate to the seriousness of his conduct and to the danger he poses to the public. Your Honor, you heard during the mitigation phase of this trial that the defendant has a long and sordid criminal history, a juvenile record of at least 13 adjudications, and a trip to ODYS did nothing to rehabilitate him. As a young adult, he committed a burglary, was placed on probation, and while on probation, went ahead and robbed somebody at knife point. The defendant did 8.5 years in prison and still was not rehabilitated. He came out, and 6 months later, on Good Friday, on April 14th of 2017, walked into Mr. Carr's on Lakeshore Boulevard and ended the lives of 2 innocent people, killed a dog, and forever altered the lives of their family. Your Honor, the third prong that you need to consider is that you must find that one of the 3 statutory factors are present, and that's that the offender committed one or more of the offenses while he was under post-release control for a prior offense. Well, he was. He was on post-release control for his 2008 burglary. At least 2 of the multiple offenses were committed as part of one or more courses of conduct, and the harm caused by those was so great or unusual that no single prison term would adequately reflect the seriousness. Your Honor, he killed 2 people. For what? As Mr. Schroeder stated last week, for some cash and 2 used cars to end 2 lives and a dog? And that the offender's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crimes. It's been abundantly clear, Your Honor. All 3 of these prongs, of which you need only meet one, apply to Joseph McAlpin. The one thing we didn't hear today, Your Honor, was any remorse for the crime. We didn't hear any condolences to the family. The only ones we heard were the half-hearted attempts while questioning witnesses, making his self-serving, unsworn statement, and in his closing argument. And the one thing that he repeatedly talked about during his argument was family. That the state's going to commit an aggravated murder with prior calculation and design of him without considering his family or the fact that he has kids or grandkids or that he's a son and a brother or an uncle and a nephew. Well, Your Honor, the defendant is sitting there today because of his actions, his choices. Colin, Corinne, and young Kane are without a mother, a father, a stepfather, a stepmother because of his actions through no fault of their own. They're without a dog, a family dog that was loved by Colin, used to go with him everywhere because of his actions through no fault of Colin's, through no fault of Corinne's, through no fault of Kane's or any of their other loved ones. Michael and Trina were a son and a daughter. They were an aunt and an uncle. They also had people that loved them. And you heard testimony, Your Honor, through the course of 5 weeks. Mr. Carr's was like a family. It was a second home, as Colin called it. One of the ironic things about the timing of this trial was not only were we in session on the 2-year anniversary of the homicides on April 14th, but Randy Kuznick opened Mr. Carr's on April 1st of 1977. So we sat through this trial that effectively closed that business forever on the 42nd anniversary of its opening. You heard Colin testify that they had repeat customers for years and years. If something was wrong with the car, bring it back. Mike, Butch, one of them would fix it. It was almost like a lifetime warranty. You saw the people that they dealt with. You heard testimony from Daryl Sanders, the last person who had any contact with either Michael or Trina when he spoke with Trina at 5:30 p.m. on April 14th to tell her there was a problem with the title. He had known them for 10 years. He was still buying cars from them. In fact, he thought he may have paid too much for a used minivan, but still had no problem calling him, and they decided they'd work it out on Monday. You heard from Albert Martin. Albert's led a rough life, but you heard that Mike and Trina kept him around to do odd jobs around the dealership because it kept him out of trouble. It kept him off drugs. It was something for him to do. Your Honor walked through that dealership on the jury view. You saw Michael and Trina's Ford Focus that you saw in the video that was parked out on Lakeshore Boulevard. And you saw that Corinne and Kane's Easter baskets were still sitting in the back seat of that car 2 years later. The family that will never be the same are both families. But the striking difference, Your Honor, is that Mr. McAlpin's family won't be the same because of Mr. McAlpin's choices, because of his actions, and through no fault of the Kuznicks and the Zukowskis and their loved ones and their children, they will never see or speak with their loved ones again. And every year, regardless of whether it's April 14th or at the end of March, Good Friday will always have a significance to them. So they get it double. They get it Good Friday and on April 14th. Another holiday without their family members. Your Honor, the lasting effects that this case is going to have on the families of Michael and Trina necessitate consecutive sentences. The state would ask that you sentence on each of those 8 counts a maximum possible sentence and run them each consecutive to each other. Thank you.
Okay, one housekeeping matter. We've got 1 year and 3 year firearm specifications for merger.
Your Honor, each of those aggravated murder counts would have a 3 year firearm specification pursuant to Revised Code 2914B1G. Your Honor is required to run the 2 most serious firearm specifications for aggravated murder, aggravated burglary, or aggravated robbery consecutive to one another and everything else. So we would ask that after those first 2, I would agree that they would merge.
Okay, and you prefer to have the sets go forward under the 3 year gun spec?
Correct.
So we,
Thank you, Your Honor.
very good. Okay, the court's going to proceed to impose sentence at this time. With regard to count number 1, the aggravated murder of Trina Tamola Kuznick, the court's going to impose a sentence of death plus 3 years on the firearm specification. Count number 2 for the aggravated murder of Michael Kuznick, death plus 3 years on the firearm specification. Count number 8, aggravated robbery. This involves the robbery of Trina. 11 years plus 3 years for the gun specification, consecutive to each other. Did I say count 8?
Yes.
Thank you. Count number 7, going a little out of order here. Aggravated robbery of Michael, 11 years plus 3 years for the firearm specification. Count number 11, aggravated burglary on Trina, 11 years plus 3 years for the gun specification. Count number 12, aggravated burglary of Mike, 11 years plus 3 years on the firearm specification. Having a weapon while under disability, count 21, 36 months. Count 23 and 24, both grand theft, 18 months each. And count number 26, cruelty to animals, 12 months. Counts 21, 23, 24, and 26 do not have any specifications attached thereto. With regard to the case at chief, obviously, counts 7, 8, 11, 12, 21, 23, 24, and 26 will in fact be served consecutive to each other, and this is necessary to properly protect the public from any future crimes that the defendant might commit and are proportionate to the seriousness of the offense. And finally, the court does observe, as stated in the pre-sentence report, that the defendant was on post-release control when he committed the offense and does have an extensive criminal history. Is there anything further? I don't think I've overlooked anything, but double check now, please. Oh, yeah.
Your Honor,
Yep.
just for clarification of the record, just want to make sure your findings that the aggravating circumstances outweigh the mitigation in both counts 1 and 2 applies to each.
That's correct.
Thank you, Your Honor. That's it.
Yeah, I didn't say both counts, but yeah, that was what I was trying to imply.
Your Honor, also there, I mean, I know it may be a moot issue, but post-release control.
I was just going to take care of that, in fact, yeah. 5 years mandatory post-release control relative to counts 7, 8, 11, and 12. 3 years post-release control with regard to counts 21, 23, 24, and 26. Obviously, 5 years would be guiding, and kind of moot, but nonetheless, I think that properly takes care of all the sentencing. What do you think? We're done? Okay, Mr. McAlpin, you do have the right to appeal this case. You have the right to have transcripts prepared. If you cannot afford the cost of appeal, the court will appoint or will pay for the cost of preparation of transcript and order the documents prepared without cost. And you have the right to have a notice of appeal timely filed on your behalf. Mr. McAlpin, I assume you want this case appealed?
Yes, Your Honor.
Okay. And unless you indicate otherwise later, the court will appoint Thomas Ryan to represent you. And because this is capital, I will appoint Bob Dixon to be a second appeals attorney on this. And
Excuse me, Your Honor, you said Thomas Ryan?
Thomas Ryan,
I believe I had him before that's not, we had him before, we had.
Can we have a brief sidebar on that, Your Honor?
Certainly.
I don't know if I'm approaching.
Yeah, you're still in this.
Yeah, he represented him in his 2003 case initially.
Oh, yes. Okay, no problem on that. Okay, we're going to appoint Bob Dixon to represent you. I'll appoint a second when I review the assigned counsel to see who is appeal eligible and has the necessary background. One last matter that was brought up at sidebar is that it's kind of silly under this case, but if you violate the terms and conditions of post-release control, any violation will result in additional prison time under this case number not to exceed 50% again, that which the trial court has put into place. Okay.
And also, Your Honor, for the record, just facts and findings and conclusion of law for the hearing we had on the 13th.
Absolutely, absolutely. That I haven't forgot about you. Anything else?
One more, Your Honor. Nothing.
Well, you are indigent.
Yeah, that's what yeah.
Okay. Court costs will be suspended in this case.
Thank you, Your Honor.
Thank you.
Please rise.
Everything has been building to this. The prosecution has argued future danger, lack of remorse, and irreversible harm to the victims' families and the community. The defense has no final emotional appeal left. From here on out, it's pure consequence. This isn't about arguments anymore. It's about finality.
I think so, yes.
All rise. Court is now in session. I will Sherry Madej presiding.
Please be seated. Good morning, everyone. Ladies and gentlemen, this morning it is my duty to advise you of your constitutional rights. These instructions are important, so please listen carefully. Under the Constitution of the United States and the State of Ohio, persons charged with the commission of an offense are guaranteed certain basic rights. They are the right to know and understand the charges against you, the right to a speedy trial, the right to a trial by a jury, or you can give up that right and have your case tried directly by a judge without a jury. At trial, the state of Ohio has the burden of proving your guilt by evidence beyond a reasonable doubt. You have the right to meet your accusers face to face and to cross-examine witnesses for the prosecution. You also have the right to summon or subpoena witnesses on your own behalf. You do not have to testify against yourself. You have the right to counsel. If you're unable to afford an attorney, the court will appoint a lawyer to defend you. You will be assessed a $25 fee for an appointed attorney. You will not be denied an attorney if you're unable to pay this fee. At the end of your case, you may be ordered to pay the fee if your judge determines you are financially able. If you choose to hire your own attorney, you have a right to a reasonable continuance to hire one. You are not here for the trial of your case this morning. You are here for your arraignment. An arraignment is your opportunity to be informed of the charges against you, for bond to be set, and for you to enter your plea. You do not have to make any statement about the charges against you, but any statement made by you can be used against you. As your name is called, please step forward. You will be asked when you received a copy of your indictment or information, and whether or not you understand the charges against you. By law, you have 24 hours before you must respond to the indictment or information. If it has been less than 24 hours since you received a copy of your indictment or information, but you wish to be arraigned anyway, you may waive the 24-hour notice and we will complete your arraignment this morning. If your case is going forward by way of information, I will ask your attorney to place on the record that they discussed with you waiving presentment of your case to the grand jury. You will be asked 4 questions. If you understand the charges against you, if you knowingly and willingly signed the waiver, if you consent that charges proceed by information instead of indictment, and if you wish to continue to be arraigned by waiving the 24-hour notice and the reading of the information. You will be asked how you plead. A defendant may plead not guilty by reason of insanity, or with the consent of court, no contest. If you want to plead guilty and you do not have an attorney, the court will assign counsel for you so that you may have a full understanding of your constitutional rights. Your case will be assigned to a judge whether you plead guilty or not guilty. If you refuse to plead, the court will enter a not guilty plea on your behalf. If you have been charged with the crime of violence and/or drug offense, under Ohio law, you cannot knowingly have, carry, or use a gun, a firearm, or a dangerous weapon until your case is concluded. This is called being under a disability. If you violate this disability, you could be charged with a separate felony offense in addition to the original charges you are being arraigned for today. Even if you have a CCW permit, you are still under a disability until your case is over. In fact, upon indictment, the sheriff who issued the permit shall suspend it until your case is over. Finally, if you are over 18 and you have not provided a DNA specimen since 2011, you may be required to submit one within 24 hours of your arraignment. Inmates in the county jail have the right to be present in the courtroom. Mr. Corrigan, do you have anyone in the jail that wishes to be in the courtroom this morning?
2 men, Your Honor, Mr. DeQuan Martin and Rodney Cuthbertson. We're going to send them over tomorrow.
Okay, thank you, Mr. Corrigan. We're ready for
You're
our
welcome.
first case.
We'll start in courtroom, case number 630080, co-defendant A, Devontae Nettles.
Good morning, Mr. Nettles. How are you today, sir? Good. Do you have an attorney?
No,
Do you have the money to hire one?
before we get on soon.
Okay, tell me who you're going to hire. Do you know? Okay. All right, the court will appoint 2 attorneys because of the nature of this case to represent you, all right? Have you received a copy of your indictment? And when did you receive it?
Yesterday,
Yesterday? Has it been 24 hours?
Probably.
Okay. All right. Do you understand the charges against you? Do you wish to waive the 24-hour notice so that we can proceed today? Okay. Do you wish to waive the reading of the indictment in open court? You have the right to have me read you the entire indictment in open court. Do you want me to read it to you? Okay, so you waive that? Okay. By waiving it, it means you're giving that up. Okay. Do you wish to enter a not guilty plea today? Okay, sir, I accept your not guilty plea. The court will appoint attorneys Fernando Mack and Rufus Sims to represent you in this case. Your bond is set at $5 million. That's a cash surety property bond. You're ordered to have no contact with the surviving victims in this case. Your case is assigned to the docket of Judge John Satula. Your first pretrial will be on July 11th at 9 a.m. Okay? Good luck, sir.
Andrews. Co-defendant B, Matez Andrews.
Mr. Andrews, how are you this morning? That's not you? Are you Mr. George? Okay. Can we do Mr. George? Okay.
Set for the co-defendant C, Aaron George.
Mr. George, do you have an attorney, sir?
No, my dad about to give me a lawyer.
Okay, do you know who your dad's going to get you?
No.
You don't know his name? Do you know if your dad has paid anyone yet? He has paid him?
Like he put a house up for that.
He put his house up? Could that have been for your bond?
No, for my lawyer.
Okay. All right. Do you know if your lawyer was supposed to be here this morning?
No.
You don't know? Okay. All right, Mr. George. Have you received a copy of your indictment?
Yes.
Do you understand the charges against you?
Yes.
When did you receive it?
Yesterday.
Yesterday? Has it been longer than 24 hours?
No.
No? Okay. Do you wish to waive the 24-hour notice so that we can proceed today?
Yes.
Okay. Do you wish to waive the reading of the indictment in open court this morning? Do you know what that means?
No.
Okay. So you have the right to have me read the entire indictment to you in open court. You want me to read it to you? Okay. Thank you. Okay. This is the matter of the state of Ohio. How do you pronounce your first name?
Aaron.
Oh, okay, you're not Mr. Andrews. Aaron George. The state of Ohio versus Aaron George. Case number 630080. Dates of offense, June 20th, 2018. Count 1, aggravated murder. This is an unclassified felony in violation of 2903.01C. The jurors of the grand jury of the state of Ohio, within and for the county aforesaid on their oaths, in the name of and by the authority of the state of Ohio, do find and present that the above-named defendants, on or about the date of the offense set forth in the county of Cuyahoga, unlawfully did purposely cause the death of S.N. 2/6/2009, who was under the age of 13 years of age at the time of the commission of the offense, to wit, February 6, 2009. There are 3 firearm specifications on count 1. The first is a 1-year firearm specification pursuant to 2941.14A. The grand jurors further find and specify that the offender had a firearm on or about his person or under his control while committing the offense. The second firearm specification is a 3-year firearm specification pursuant to 2941.145A. The grand jurors further find and specify that the offender had a firearm on or about his person or under his control while committing the offense and displayed the firearm, brandished the firearm, indicated he possessed the firearm or used it to facilitate the offense. The third firearm specification is a 5-year firearm specification, drive-by shooting, pursuant to 2941.146A. The grand jurors further find and specify that the offender committed the violation of Section 2923.161 of the revised code, or the felony that includes as an essential element purposefully or knowingly causing or attempting to cause the death or physical harm to another, and that the offense was committed by discharging a firearm from a motor vehicle other than a manufactured home. The state of Ohio reserves the right to seek a superseding indictment containing the appropriate 2929.04A aggravating circumstances specifications. This offense is contrary to the form of the statute in such case made and provided, and against the peace and dignity of the state of Ohio. Okay, that's all count 1. There are 10 additional counts. Would you like me to keep reading? No? So you waive the reading of the remainder of the indictment in open court?
Yes.
Okay, sir. Do you wish to enter a not guilty plea?
Yes.
Okay, I accept your not guilty plea. Because you don't have counsel with you right now, I am going to assign counsel to represent you to make sure that you're represented through all the proceedings in this matter, okay? If you choose to hire or retain a lawyer going forward, it's an easy fix. They can file a notice of appearance, okay? All right. Mr. George, the court appoints Attorney Thomas E. Shaughnessy and Attorney David Grant to represent you in this case. Because of the nature of the indictment, the court will appoint 2 attorneys to represent you, okay? Your bond is set at $5 million. That's a cash surety property bond. You're to have no contact with the surviving victims in this case. Your case is assigned to the docket of Judge John Satula. The first pretrial is on July 11th at 9 a.m. Okay?
Co-defendant B, Matza Andrews.
Good morning, Mr. Andrews. How are you this morning? Okay. I need you to speak up just a little bit louder, all right? Do you have an attorney, sir?
No.
Do you have the money to hire one? Okay. The court will appoint 2 attorneys to represent you in this case because of the nature of the indictment. Sir, have you received a copy of the indictment?
Yes.
When did you receive it?
2 days ago.
2 days ago, so it's been longer than 24 hours?
Yes.
Do you understand the indictment?
Yes.
So you understand the charges against you. Do you wish to waive the 24-hour notice? So you're allowed 24 hours before you have to come and stand before the court and enter a plea. You've had it longer than 24 hours, correct? So you're okay with waiving that 24-hour notice?
Yes.
Okay. Do you wish to give up the right to have your indictment read to you in open court? Okay, do you want me to read you the entire indictment right now in open court? No? Okay, so you want to waive that? Okay. Do you wish to enter a not guilty plea today?
Yes.
Okay, I accept your not guilty plea. The court will appoint attorneys James McDonnell and John DeCaris to represent you in this case. Your bond is set at $5 million. That's a cash surety property bond. You're ordered to have no contact with the surviving victims in this case. Your case is assigned to the docket of Judge John Satula. The first pretrial will be on July 11th at 9 a.m. Okay? All right, that's it.
This is where the emotional weight crashes in. The court is laying out a life filled with trauma, abuse, neglect, addiction, mental health struggles. These are textbook mitigating factors. But notice something important. Mitigation explains behavior. It doesn't excuse it. The judge is signaling that despite all of this, the law still demands accountability. Let me ask you,
If we can do that uninterrupted to allow me an opportunity to place on the record why we're here today. Is that something that we can agree on? Thank you for nodding your head. All right, with respect to today's hearing, the court, after sentence in the courtroom last week, was advised by counsel that in fact we had missed some of the items that needed to be discussed with respect to sentencing. For example, the repeat violent offender specification, the notice of prior conviction. There were some additional verdicts that needed to be read with respect to the bench trial that was held by the judge, by myself during that trial. With respect to that notice being provided to the court is in a situation where the sentencing had never really taken place. I had not signed any journal entries regarding the sentencing. And in fact, looking at legally and the responsibility that I have as a judge legally, I found that having a resentence of the matter would be what was inclined to have to take place, having to go through that process all over again, and having an opportunity for the state to speak, and also an opportunity for you to speak, to have that evidence presented. As a judge and a lawyer, I've spent my whole career, almost 26 years, with the bench and public communities, public groups, and bar associations, doing one thing, which I always found to be important, is promoting confidence in our justice system. I'm concerned that the hearing last week eroded the trust that I worked so diligently with others to build. In retrospect, while there is legal precedent for gagging a defendant to keep order in the court, I apologize for taking that action last week. My decision to end your outburst came after I had exhausted every other attempt to restore order to a hearing that you continuously impeded. Despite many warnings for you to stop your frequent and offensive outbursts, I believe it was over 60 interruptions in 54 minutes, you continue to interrupt and hinder the legal procedures of the court. Procedures that are designed to protect your rights, the rights of the victims, and our justice system. It escalated to the point that as a judge, it was my responsibility to take control of the hearing. As the court is the foundation of justice and fairness, a judge, such as myself, has the responsibility to maintain control of the legal process that occurred. Knowing that a defendant is required to be present at all times during the sentencing, I acted with those principles in mind. And the sheriff, they followed their department policies and procedures in order to restore the order that was happening in the courtroom to proceed with my hearing. There are many questioning whether those actions were just or fair. However, the sentence that I ordered, I believe, was even-handed and impartially imposed, and based on the facts of your crimes, the impact on the victims, as well as the need to protect society from further criminal activity. You were convicted by a jury, and the jury convicted you of aggravated robberies and robbery, kidnapping, all while you used a gun. Now, while you faced a potential maximum consecutive sentence of 134 years, I ordered a 24-year sentence. Due to your many criminal violent acts, the 3 victims that you held at gunpoint have had to live in fear for several years. And I continue with that hearing despite the disruptions in order to give closure so that they could heal and move forward. That decision may have had the opposite effect. And for that, I apologize to those victims. To my colleagues on my bench here in Cuyahoga County, and to the 700 judges in the state of Ohio, I regret any impact or repercussions for my actions last week. I never want the fairness and justice that each of you deliver in your courtroom to be questioned, no matter the circumstances. A judge has a moral and ethical obligation to avoid the appearance of impropriety. In this case, the sentence I imposed was not final, and typically the case would come back to me for further action. And although I sit here today, and I am confident that I can remain fair and impartial in concluding this case, to maintain the confidence of our justice system, and to leave no question in anyone's mind as to any bias, I am going to recuse myself and I will request the Ohio Supreme Court to appoint a new judge to conduct your sentencing. I'm going to order a pre-sentence investigation report for that judge, a mitigation report along with the transcript of the trial, and that will be given to the newly appointed judge, so that judge has all the information in this case. This time I'll conclude my thoughts. Anything for the record? Yes, on behalf of Mr. Williams.
Yeah, thank you, Your Honor. On behalf of Mr. Williams, Judge, at this point, on his behalf and to preserve any sort of error for Mr. Williams, I'm going to have to object to your recusal. And the reason is this, Judge. As indicated in the last hearing, I won't go over the details, but as I let you know, we made a motion to have a competency exam done upon Mr. Williams. We tried to provide enough good cause to this court based on any communications that I've had with him since he's returned. And even as late as today, there's an inability to communicate with us. Now, whether that's feigned or not, I don't know. You made a decision the other day that it was feigned. All I know is I have a client now that may or may not be competent, and I can't have a meaningful discussion with him on whether or not even we should object to your recusal. And the reason is this, Judge. This case could go forward to another judge, okay? And depending on that judge looking at the PSI, looking at the facts, looking at all the circumstances, that judge may say, whoa, I think a sentence of under 24 years is much better. But the judge also could decide that a sentence up to 130 or whatever it was years might be more appropriate. And so to preserve that error, and for that purpose, I am objecting to your recusal. Thank you, Your Honor.
Thank you. Before hearing from the state, I will just say to you that with respect to a competency evaluation, I could order a competency evaluation. It was pretty clear on the record that your client's concern was his loss of memory because of what he alleged to be an incident in Omaha, Nebraska, when he fled there. So when I asked him, it was very clear when I read the transcript that he says, Judge, I don't have any mental health issues. I don't have any IQ issues. I'm not asking for a mental health evaluation. Those were some of the reasons, including others, why I continued with the hearing last week. I'll also note your objection for the record. I'll add a competency evaluation to see if this court psychiatric clinic can do that as well for him to provide that information to the judge.
Your Honor.
But as I said, in order to avoid that appearance of impropriety, again, having that obligation to do so, I want a confidence in this judicial system that I have so hard to work for, and to leave no question in anyone's mind as to any bias. And I'm gonna maintain the order of my recusal.
When you specifically when you are asking for that competency exam, I would ask that there be neurological testing done, because the key, if based on what was said in the hearing, that there was hit on the head, or there could be neurological deficits. So we need to, I'm just for the record, I want to explore all of those.
All I'll say is I'll refer to, I'm not the expert in my court psychiatric clinic. I'll leave that for them to make that determination based on his comments that he makes to them regarding whatever injuries he has sustained. But I'll order that, and at this point allow the subsequent appointment of the judge that will be done by the Supreme Court to handle those matters.
All right, thank you, Your Honor.
You're welcome. State.
Your Honor, we ask that the court order the exam to also test for malingering. We have nothing more for the record at this time.
All right, thank you. All right, so I'll order and put that on as of today, so we'll adjourn. Thank you.
All right, can I say something? Freedom of speech, no duct tape.
Okay.
Freedom of speech, no duct tape. With the hashtag.
Hey, what do you need? Excuse me. You need the attorney? I got another radio.
again, Andrea. Keep Mr. Williams up. All right. Thank you. Be seated. All right, so we're back on the record. So, Mr. Williams, as I was leaving, I heard that you wanted to make a statement, and so go ahead.
Freedom of speech, no duct tape.
Anything else you want to say?
Freedom of speech, no duct tape.
And so I'm giving you an opportunity to speak. What would you like to say?
That's all I got to say, Your Honor. Freedom of speech, no duct tape.
Very good. I just wanted to make